Welcome to this episode of Divorce, Parenting and Property Matters, Legal Insights by Village Family Lawyers, where we share practical family law insights for people navigating separation, parenting and property matters. Today, we're talking about how family trusts are treated in a property settlement and why the answer has almost nothing to do with whose name is on the title. There's a sentence we hear more than almost any other from clients who hold assets through a family trust. It's not in my name, and it's a completely fair thing to think. A discretionary trust is built to separate ownership from benefit. A trustee holds the assets. Beneficiaries might receive distributions at the trustee's discretion. Nobody owns any particular asset outright. In most other settings, that separation holds. It's the whole reason the structure exists, and it does that job well. Family law asks a different question. Not who owns it, who controls it, and who benefits from it. Let's firstly look at control. It is more concrete than people expect. Control means the practical kind. Who holds the appointor role, which is the power to remove and replace the trustee. Who the trustee actually is, whether one party is a director of the corporate trustee, who's been directing the distributions. That last one matters more than the paperwork does. If somebody can appoint the trustee, direct where the money goes, and use trust assets as their own, then the fact that a company holds legal title describes the structure rather than the reality. Now let's look at benefit. This is where the evidence usually lives. What has the trust actually done for this family? Distribution history is very often the most revealing document in the file. A trust that's been paying school fees, funding holidays, covering household expenses for a decade, that isn't a distant structure, however it reads on paper. So where does that land? Two possibilities broadly. Where control and real benefit both sit with one party, the trust assets can be treated as property, which means they go into the pool available for division. Where control genuinely sits with someone else and the person is one beneficiary among several, it's more likely to be assessed as a financial resource, and that's not a neutral result. A financial resource is taken into account when the court looks at each person's future needs. In practice, it can mean the other party receives a larger share of the assets that are available to account for the wealth one person has access to. A few things worth knowing beyond that. Trusts set up before the relationship aren't automatically protected. A trust that stayed genuinely separate, made no distributions to the couple, played no part in their financial life, that's in a much stronger position. A trust that held the family home or absorbed income earned during the relationship is a very different proposition. Where other family members are genuinely involved, it changes things. If parents or siblings also benefit and control is genuinely shared or held by someone outside the relationship, it becomes considerably harder to characterize those assets as belonging to one couple. A trust a parent established and still controls is not the same as one a couple set up and ran for themselves. Disclosure covers all of it. Trust deeds, variations, financial statements, tax returns, distribution records, loan accounts. And if you're a director of a corporate trustee or you hold the appointor role, that gets disclosed too. You can't leave a trust out on the basis that you don't personally own its assets. We should address one more thing plainly because people think about it and rarely ask. Moving assets around in anticipation of a settlement is a poor idea. Courts have powers to deal with transactions made to defeat a claim, and that includes transfers into or out of a trust and changes to a trust deed. The consequence is usually broader than the transaction itself because it affects how everything else that person says is received. If you're restructuring for a genuine commercial or succession reason while a separation is underway, take advice first rather than afterwards. Here's the part we'd want you to take away. A family trust doesn't put assets beyond reach, and it doesn't make a fair outcome harder to reach. What it does is make the picture more complicated, and complicated pictures reward preparation, which is mostly about getting the valuation and the structure properly understood early. Most matters like this don't need a courtroom. They need better financial preparation than a straightforward property division does. If a trust forms part of your situation, understanding how it's likely to be assessed is the foundation for every decision that follows. An initial consultation covers your position, how your structures are likely to be treated, and a practical plan for what comes next. You can book at villagefamilylawyers.com.au or call 1300413997. The full article is in the episode notes. This has been Divorce, Parenting and Property Matters. Legal Insights by Village Family Lawyers. Thank you for listening.